Yes. Do you get my voice?
Yes, and I'm sorry. We also there's Shifsan Ahmed and then um, Hossein Mahoutoum. So perhaps in that order. Please proceed.
Hi,
We can hear
Professor.
you. Yes.
I will help you take the questions. First, we'll start with Sun Online.
Yeah, thank you. My question is, uh, after today's decision, many who oppose Maldivian government's stance are skeptical of the claim that the country has gained rather than lost, and that its sovereignty is at risk after today's decision. As as the lead counsel, what is your opinion on this matter? Thank you.
Well, thank you for your question. It's very see how the Maldives has possibly lost any sovereignty. In fact, as I explained, there was an area of overlap um, between the two countries, which would, under the principles of international law, which have been established for 100 years, be divided based on the equidistance principle. And in fact, Maldives received the bigger share, 47,000 kilometers compared to Mauritius, 45,000 square kilometers. And that is a very good result by any measure. And on the even bigger issue of the additional 22,000 square kilometers of overlap that Mauritius had claimed, it received nothing. And the court unanimously, I should add, unanimously, all 9 judges accepted the Maldives' arguments that Mauritius has failed to provide evidence that it has any entitlement to a continental shelf beyond 200 nautical miles. So my colleague, Professor Tuvelan, and I, we have each of us more than 30 years of experience before international courts and tribunals. This is not the first case that we've argued on maritime delimitation. So this equidistance relevant circumstances principle that was applied by the special chamber has been applied in numerous other cases. So in that regard, I don't think there should be any concern that the Maldives has lost anything. If anything, it has gained.
If I may add, that's a good question, and that's a question that every state will ask after a delimitation of maritime boundary. Did we lose sovereignty on somewhere? But the point is that until there is a delimitation, there is no fixed area on which a state can say, I'm sovereign there. You have claims, you have overlapping claims, and then there is a delimitation. So the question is the methodology of delimitation applied by the tribunal breaches the sovereignty or goes against the sovereignty of one or the other state? Maldives in this case, the answer is no, because the tribunal applied the law. And the law, as we say, professors of international studies say that, and I believe in that, we say that abiding, so for example, creating and abiding by international law is not going against sovereignty. It's an expression for a state of its sovereignty. So that's my analysis I can bring to your question.
Now I'll pass to Shifsan Dieres.
Thank you. I hope my voice is clear. I have 2 questions for you, professors. The first question is, while the special chamber has applied equidistance and relevant circumstances method to the delimitation, according to the judgment of the plus Maldives has not raised any relevant circumstances in order to adjust the provisional equidistance line in our favor. Could you please specify why Maldives chose not to raise any such arguments, such as historical fisheries rights and the socio-economic importance of the area for Maldivian fishermen, especially southern fishermen, and the probable catastrophic impacts of the fisheries practices of Mauritius, which might have a very negative impact on the livelihoods of southern fishermen, especially. Uh, the second question is also concerning about these fisheries practices of Mauritius. Professor Ahwan mentioned that Mauritius has given a commitment to continue the protected maritime area status, which was given by the British to the Chagos maritime area. My question is there any mechanism to make sure that Mauritius maintains this status in the future? Or does the judgment have any bearing on this issue, any legally binding decision to make Mauritius keep providing the commitment? Thank you, sir.
Thank you. Those are very good questions, very sophisticated questions, if I may say. First of all, in our pleadings before the court, we make very clear the importance of this maritime area to the government and people of Maldives, in particular in respect of tuna fisheries. And this featured in the written and oral pleadings that we made before the special chamber. But it's a different matter to say that there are historical rights which would affect the boundary, especially when the difference between the boundaries claimed by each side was relatively small. If you look at the overall area of, let's say, 90,000 square kilometer, a very small fraction of that was actually in dispute between the Maldives and Mauritius. So under those circumstances, it would be very difficult to say that historical fisheries should somehow adjust the line. And in cases where historical fisheries have been irrelevant circumstances, you've had very specific circumstances. And in particular, when you're that far offshore, it becomes that much more difficult to, let's say, there's a very specific lump that the fishers were respecting, which should now be upheld by the special chamber. As to your second question, the question of the marine protected area was not part of the dispute before the special chamber. But as part of the Maldives presentation of its case, it emphasized, as I just said, the importance of